Court of Appeals for the First District of Texas now in session. Move to appeal the Constitution.
Please be seated. Good afternoon. Welcome to the First Court of Appeals. We have two cases on the docket this afternoon. They are 0123000725CB, Lily Lerner versus Douglas Scott Lerner, and 0123000843CB in Ray Lily Lerner. Starting with Appellant Counsel, will you please make your announcements?
Good afternoon, Judge. Ms. Eva GUZMAN and Roy James on behalf of the relator in the original proceeding and Appellant in the record.
Thank you. Appellee?
Good afternoon. BRIECK on behalf of Douglas Lerner, and also have been here counsel as well.
Thank you. And I understand the appellant, you're divided your time between co-counsel 15 and 5 with 5-minute rebuttal?
That's correct, Your Honor.
Okay, great. And then just before we begin, I know you're all familiar, but when the light turns yellow, you have 1 minute. And of course, red means stop. And of course, continue the answer to your question if you're in the middle of answering that question. We have read the briefs extensively. I know this is a very important case for the parties, involving very important issues to each of them. And so we've taken the care of deliberation of really studying the briefs. There's a lot of facts and evidence here, and while we're familiar with it, we really appreciate you guiding us through the record and some of these difficult questions that we have to answer and resolve today. With that said, Appellant, we're ready to proceed.
May it please the court. This modification case makes clear there's no magic wand, perfect solution, perfect decree, or shatterproof glass house that can 100% insulate the children from the conflict that's woven into the tapestry of divorce. Relatedly, what the law makes absolutely certain is that a trial court cannot take a hammer when a scalpel is required. That's an abuse of discretion, and it is devastating for the children. I want to begin with what I believe is the most important issue in this case. The trial court's change in primary residence, taking the children from the only home they'd ever known, uprooting them. There is no evidence and no finding that supports that. And so to resolve this case, we need to look at two documents. I'm going to invite the court to look at our bench exhibit, and the other document is the findings of fact and conclusions of law. As I'll explain, this is your record. This cabins and governs this court's review, these 6 pages of findings. So back to our exhibit, there are two concepts, distinct concepts at issue here. Physical custody, which is the physical care, the supervision, the place of residence, and then there's legal custody. And if the court looks at the record, at the opening statements, Mr. Hoffman, counsel for Mr. Lerner, said, Judge, we're seeking changes in legal custody. Oh, and my client also wants to change physical custody. Two distinct areas.
And now, counsel, dividing those two separate, because we understand that there's two separate questions here. As to the legal custody, we understand that the mother in this case also petitioned or counter-petitioned for some changes in legal custody. And can you tell us why, when we're evaluating whether there was a material change in circumstance, there was not a judicial admission at least as to the legal custody, so that we can then focus on the physical custody here?
That is a very fair question. The legislature changed the statute to make clear that if you plead a change in one element, you don't plead it as to all. And I do believe, even though there is a lot of case law that says if you contemplate it, you can't elevate it, I would not quarrel with this court if it decided that there was a material and substantial change in legal custody. There are very technical arguments that say otherwise, but that is a great place to start, and I don't disagree with the court.
And your position would be that notwithstanding, there still has to be a separate substantial material change that would have supported the change in the physical custody of the children.
Let me get back to the findings. Because the court filed findings of fact, we requested additional findings. The court didn't find them. And so these findings are what cabins your review of the record. There's nothing in these findings that would support a change to physical custody where the children live. And that's not unusual. The disagreement here, the crux of it was we can't make joint decisions about eds, meds, and heads. That's what they said in my family law days. It's education, medical, and psychological. And this court, and it's critical that these findings cabin your review. This court said in 2018 in Karanja v. Smith, the relief the trial court may grant must be connected, somehow connected to the changed circumstance. The court repeated that in ATE, and there are courts around the state that accept. And there's a reason for that. They should be connected. Just because you come in and you say we can't agree about how to make decisions, the state prioritizes finality and stability in these children's lives. You don't pull them out of their homes, their schools, their friends, their support systems because the parents can't agree on who should take the child to the doctor. In this case, the record shows Lily Lerner attended 98% of the appointments. That's for the court to look at, but that disagreement cannot sustain. And the reason in this case is because we filed a request for additional findings of fact. The court refused to make it. We said, tell us what the connection is. Tell us why you decided to change primary custody. The court refused. This court even gave an example in Karanja. The court said, a remarriage may require some changes, but that does not mean that the trial court may now modify other provisions. In that case, it was the original decree, unrelated to the marriage, unrelated to the real issue before the court.
Counsel, there were additional findings of fact here in the court's order beyond just the inability to co-parent. There were findings that the tiebreaker provisions in the decree were no longer effective, that there was hostility directed towards father by mother, that there was attempt to minimize or guard the children's contact with the father, and that there had been some disruptive behavior by the mother. And at this point, as you know, we have to defer to the trial court's credibility on these issues. I know they were contested, but these were the findings of the court, and there was at least some evidence that while the children were residing with mom, the allegation is that there was some care or some therapeutic needs that were delayed and impaired. Why does that not support both the change in physical custody and the best interest determination finding as to that issue?
That's an excellent question. We don't know. And this court's job, when we've requested additional findings of fact, is not to scour the record, to connect the dots. That's the trial court's job when we file a request for additional findings, specifically asking her, connect the dots. The second point, Lily has exposed the children to hostility. If the court, take what Doug said is true, Lily flipped him off. One time in 6 years. If you're going to disrupt the children's home, school, peers, because a high conflict couple, Lily said it didn't happen, but accept Doug Lerner's version. That's not enough to change physical custody, and I would say it goes down here, legal custody. They can't make decisions together.
There's some of the things that the facts may support that go to legal custody also can bleed over into physical custody. For example, they make the allegation, and I assume that it's a fact that's implicit in the findings of fact, but that Lily, as far as medications are concerned, as far as the growth hormones are concerned, did double doses of growth hormones, and this allegation of, as far as the ADHD medication is concerned, sabotage that, and that, of course, the day that she started taking it, she had all these things. Aren't those sabotaging medical decisions there go to physical custody?
First of all, the medical records speak to that. Second of all, with the ADHD, each parent had concerns. Mr. Lerner is on Lexapro, marijuana, Adderall and Xanax, Lily rightly had concerns about the ADHD. That goes to legal custody. At the end of the day, the amicus in this case, and I want to just say, Kelly Fritz, board certified, appointed by the court, the amicus order says she's appointed to advocate for the best interest of the children and to assist the children. She made statements in her closing. She's the only person who met with the parties, interviewed the children, looked at all the records. She's the only real neutral person who saw them outside of the courtroom setting.
Counsel, if we agree with you that there is sufficient evidence to support the change in legal custody, but not the physical custody, what would be the appropriate remedy here?
The court can vacate and should vacate the order with respect to primary residence, as noted in our brief. Mr. Lerner came back to court for more. There is a pending motion to modify. This court has jurisdiction here because no decision has been made over there. And this court has an obligation to ensure its jurisdiction, and before you issue your opinion, I am sure you will make sure that a judgment has been issued over there to make that moot. Vacate that. And if the court finds that one of these findings and the evidence in the record supports Mr. Lerner, who admittedly missed 98% of the doctor's appointments, and when his counsel made his closing statement, he said, well, Lily doesn't work. Mr. Lerner works. They proved beyond a reasonable doubt, he said in his closing, that Lily Lerner was the parent responsible for all of the medical. Their excuse was, Lily doesn't work. I submit she works at the home. But here's what the ad litem said. The designation with Miss Lerner remains to be in the best interest of these children. Miss Lerner, since the divorce, has provided a stable, consistent routine in her home. She's been intimately involved with the children's educational and medical needs. This is who the amicus attorney, after looking at all of the evidence, said, but the legal reason goes back to your record. Thank you.
Thank you.
May it please the court. Your Honors, I will narrowly address the attorney fee order, which is the subject of the original proceeding, and it's also challenged in the direct appeal. This order should be vacated on 3 independent grounds. 1, jurisdiction. The trial court did not have jurisdiction to sign the order outside of a strict, mandatory 60-day jurisdictional window. 2, insufficient evidence. Doug Lerner did not meet his burden of proving the award. He had to prove 1, that the award was necessary to protect and preserve the children, their safety, their welfare during the pendency of this appeal, and 2, that the fees were equitable. He didn't meet his burden. And then number 3, improper award of trial attorney fees. The statute only authorizes the award of appellate fees. However, when you look at the order, there's 2 categories of fees, and the trial court awarded trial attorney fees. So at the very least, that $103,000 awarded for trial fees should be vacated.
Counsel, on that point, the statute does not refer to appellate fees. It refers only to attorney's fees. And so, in essence, are you asking us to read appellate fees as a limitation on the language of the statute as expressly written?
Your Honor, 2 reply points. The statute, when you collectively read 109.001, it says during the pendency of the appeal, and then when you look at courts that have reviewed 109.001 orders, it says that these are for appellate fees. And Your Honor, I think this may not be a contested issue. It's my 3rd issue that I want to raise with the court, but if you look at the response brief that was filed in the original proceeding, there's no response point to that particular issue. So, I mean, I would even go as far as to say you may get an agreement or a concession from my friend on the other side on 2 points. 1, that the statute only authorizes appellate attorney fees, and 2, the $103,000 that was awarded, those were for fees incurred from motion practice in the trial court. So a reading of the statute does restrict the fees to appellate fees, and then when you look at the cases that have interpreted the statute, and we've cited to those cases in our briefing, it says appellate fees.
Are these 2 separate universes, regardless of what happens on the modification side? Is that separate from what happens on the attorney's fees issues? Meaning if we reverse in part on, say, physical custody, does that have any effect on your attorney's fee side?
Part of the order, because the attorney fee order awarded trial fees, which are improper under the statute, but also conditional appellate attorney fees, and they're conditioned on Doug being successful on appeal. So to the extent he is not a successful party in the appeal, then the conditional appellate fees are mooted. But then I think the court still has to address the trial attorney fees, which again are not authorized by the statute. So I'll circle back to the first issue, which is jurisdiction. I think that's the most direct way for the court to dispose of the attorney fee issue. I'll just state
on that point, can you address section B2 of the statute that talks about the retention of jurisdiction?
Sure. So, Your Honor, if the court is asking me about the retention argument that my colleague on the other side has made, is that this is a new subject matter jurisdiction. It's a new authority that the trial court has, and so there's it's a strict 60-day jurisdictional window. And what I think the best way to answer the court's question is to look at the cases that have interpreted the statute. So you can start with Marcus v. Smith, which is a 2009 case out of this Court of Appeals. And if you look at all of the courts that have interpreted 109.001 on the jurisdictional issue, all of the courts say it's a jurisdictional window. That's not my language.
We don't have any case where there was, quote, a premature order, right? In all of those cases, they were analyzing cases or orders that were signed after the fact, but we don't have a case that addresses what you describe a premature or / void order. And so that's the question here. It seems that the statute extends the plenary power of the trial court and to retain jurisdiction to issue these particular temporary orders during the pendency and appeal. And the only limitation I see on here is 60 days past the notice of appeal.
So, Your Honor, it's not an issue of plenary power. It's really a matter of subject matter jurisdiction. And a plain language reading of the statute, clearly the legislature was intending to award these fees when an appeal is pending. And we cited to some cases that interpret what I call the sister statute or a twin provision under the divorce, Chapter 6 divorce proceedings. And the cases that have interpreted that twin provision have said there's a start date and there's an end date, and it's a jurisdictional window. So even though we have not been able to find a case where the order was signed outside, meaning before the window, it's clear from a reading of the statute and the cases that have interpreted the statute that the fees were met if there was a pending appeal, and there was no pending appeal when the order was signed. But
is that inconsistent with the position Appellant took below? She filed the motion requesting fees under that section prior to filing her notice of appeal, seeking remedy specifically for fees.
Well, there's no waiver, Your Honor, if that's what you're suggesting. There's no waiver because the parties are allowed to file the motion before that jurisdictional window opens. The statute only speaks to when the court can actually issue it. So any party can file it prior to.
Was she also asking for her trial fees too in that motion?
Your Honor, I don't know that, and I don't want to misspeak. I do know that she asked for fees, but I'm not sure if it was for trial attorney fees. Regardless, it's not a waiver. You can file the motion prior to. What restricts the jurisdictional window is based on the trial court making the order, not when a party requests it. But if I can just briefly get to my second point, which is even if the court does not agree with me on the jurisdictional issue, the second way that this court can dispose of the attorney fee issue is insufficient evidence. So Mr. Lerner had the burden of proving that the fees were necessary. There's two things he had to prove. One, that the fees were necessary to protect and preserve the welfare and safety of the children during this appeal, and two, that the fees were equitable. He didn't meet his burden, and here's the reason why. I'll first direct the court to finding number 24. The trial court's finding number 24, there the court found that Doug, in fact, could support the children without any financial support from Lilly. That finding alone completely undercuts the element that Doug had to prove. Also,
well, that goes to child support, right? Whether there was a need for the mother to pay child support, but there was also evidence that he had, for example, had to borrow from the children's college fund to support some of the legal fees, that he had gone into debt to be able to pay for some of the attorney's fees related to the litigation, and that he, in fact, was having, quote, significant problems either choosing to maintain the children's safety and welfare or having to defend the lawsuit.
Your Honor, Mr. Lerner never testified in that attorney fee hearing that if the trial court did not award the fees, he would not be able to provide for the children's necessities.
Is that necessary?
Yeah, absolutely. The first element is that the fees are necessary to protect and preserve the safety and welfare of the children. The evidence also showed that Mr. Lerner, his income was $250,000. The evidence also showed he didn't have a mortgage payment. He was living with his fiance at the time. He didn't pay for the care or upkeep. And then also, I think what is important is that at the time this order was signed, his child support obligation was eliminated. So there was more income in his pocket, and the only income that Ms. Lerner had was taken away from her. The fees weren't necessary to protect and preserve the children, and they were not equitable. That was the second element that Mr. Lerner had to prove.
What's the status? I know the appellate fees are conditional. What's the status of the order to pay the trial attorney fees? Are they still battling that out? Or?
We had a bond issue that we brought before this court and the Texas Supreme Court, and so that has been bonded. That has been bonded. And then the last, if I may, last thing that I want to note on the insufficiency of the evidence. Again, the court doesn't agree on the jurisdictional issue. The court can dispose of the attorney fee order on insufficiency of the evidence. It's our position that the evidence shows that it was not necessary for, and again, it's tied to the children's welfare and safety. And there was no testimony from Mr. Lerner that if the fees were not paid to him, he could not, or the children's welfare and safety were in jeopardy. And then going back to number 24, it mentioned that it says the trial court found Doug could support the children without financial assistance. That same finding, this is what the trial court said. Lily has no stable source of income or resources. She had no money to pay for attorney fees, and she had to borrow it from her family. So these. So
this goes to the equity factor.
This goes to the equity. I mean, requiring Lily Lerner, who at that time the only source of income she had was taken from her, was anything but equitable. And so. My time is up. I'll just end by saying this. The court can dispose of the attorney fee order on jurisdictional grounds or independently on the fact that there's insufficient evidence to support the two elements that Mr. Lerner had to show. And at the very least, the trial fees that were awarded were improper. That should be vacated. And again, I don't think that you're going to have a challenge to that. It wasn't raised in the response brief. I thank the court for its time today.
Thank you very much. We appreciate it. We're ready for Appellee's argument, and we'll add some time. Do we know how much additional time we used up? 4.5 minutes? You will have the same additional time as Brick.
Thank you very much. May it please the court, I want to start by going in reverse for some of the issues that were raised. On that very last point, I do want to note out that we did address this issue about whether appellate fees could be awarded under the statute. That's on page 25 of our brief, note 5. The main argument that we made about that is that if that was even an issue, which we disagree that it is, the statutory language doesn't include a limitation on what type of fees can be awarded during the pendency of an appeal. But that has been waived, and in fact there was invited error. There was no complaint by Ms. Lerner in the trial court that such fees could not be recovered. In fact, the argument was the opposite.
But what is your position? Does the statute allow for the recoveries of anything but appellate fees?
We would argue that it does not. There's nothing in the language of the statute itself that limits it in that way. There's no case that's been cited or that I had located that would limit it accordingly. We know that these, post-judgment, post-trial proceedings happen in a lot of cases, and so there's good reason why some of that would be contemplated along with the contingent appellate fees. There's no authority to draw a line of demarcation either way.
Well, but let me ask you this, because at least you did concede that the statute is not punitive in nature.
Correct.
And it seems that the trial court here awarded the trial fees based on the fact that the mother had lost her motion. And so that does sound to me to be punitive in nature. So what supported the award of attorney's fees based on the standard that this specific statute provides for?
Thank you.
In other words, the welfare and safety of the children. How were the trial court fees relevant to the welfare and safety of the children during the pendency of the appeal? Exactly.
I can address that. The evidence that was offered was that Doug now has primary responsibility for the children. He is working 2 jobs. He has incurred, because of the trial court proceedings that preceded this, hundreds of thousands of dollars in debt. He's maxed out family loans. He's maxed out credit cards. He talked about the ability to care for his children in that context was significant. That was the word that he used. He's faced with using their college funds to continue defending the appellate process. This was a point that was mentioned by counsel. He testified, this is on the mandamus record, page 225, where he's talking about how he isn't able, it's not that he doesn't have to, it's he's not able to help pay for the mortgage on the house where he now lives with his wife, where the children now reside. And he explains that that's due to the cost on his home, this $1 million home.
Is that evidence, though, not relevant that the trial court was considering in order to think about prospective contingent appellate fees? Is he going to be in a position to continue this litigation and provide for the children's welfare and safety versus past looking? Like, is he entitled to an award of past fees incurred in defense of the litigation?
I think that's a fair point, except that all of this is ongoing at the same time. At the same time that we're trying to defend the appeals that took place over the bond issue and then prepare for this appeal and the direct appeal and the mandamus, the emergency motions were being filed. And all of that additional legal expense then impacts his ability to continue defending the appeal that takes place after that point. And I agree that the statute is not punitive. We had an alternative basis for seeking these fees as sanctions. That was not what the court ordered additional briefing on. That's not the rationale. That's not our rationale on appeal now, that there's somehow some way to punish. Lily's entitled to pursue her appeal. That's her right. These are important rights that need to be heard. The part that is difficult is that now he has primary custody of these children. He has primary responsibility for all their expenses and their housing. Under the case law that we've cited, that is what is sufficient to establish under the statute that these fees are necessary to the safety and welfare of the children pending appeal. Again, the issue of whether the appellate fees versus the post-trial proceeding fees can be considered, we treat that as waived. That was not an objection that was raised. Lily was making a different argument then than she is now. It certainly was not something that she brought to the trial court's attention to somehow remedy before she was pursuing that. That's not the jurisdictional issue.
Do you agree that there has to be a separate finding by the court that the award of fees has to be equitable? And what evidence was there to support any equitable finding?
I do believe the language in the order that was drafted does include the statement that it is equitable. It tracks the language in the statute. The equities, there's not a lot of case law digging into the details of what that really means. Certainly it can't mean that it's punitive and that she's somehow a bad actor for pursuing the appeal. I do think equity matters when you're talking about repeated appellate proceedings, which is what the trial court was facing, or the fact that there was all these additional motion practices that were all being initiated by Lily. Lily claims that she doesn't have the financial resources to continue legal proceedings, but then continues to instigate them. And to your point, Justice Johnson, the status is, I think there's actually a cash deposit in the amount of more than $100,000. So we know that there is at least funds for that or access to those funds. And that given the standard for what is sufficient to be necessary for the children's safety and welfare, the ability of the parties to pay and who should pay is part of the equity consideration. The trial court did have sufficient evidence, both at that hearing and from evidence that was admitted at the trial, which the order reflects that the court considered. Again, these are the non-jurisdictional issues. I want to address this issue of whether we should even be talking about jurisdiction in the first place. Our first position is that the trial court signed the order when it could sign the order, that there's no need to get to a jurisdictional question. We know that from the case law, the purpose of the statute, the language that's actually in the statute itself, and then just sort of how this plays out in terms of fairness and practical application. There is no, to your point, Justice Rivas-Molloy, there is no case that has reversed based on the fact that the order was signed before a notice of appeal was filed. So this would be the first. The purpose of the statute reflects that that would be an inconsistent with what it's trying to accomplish. The Morris case that we cite says that the plain purpose is to establish that while the appeal is pending, the children's safety and welfare is preserved. And the statute itself uses that phrase. That's sort of where all this crops up, that it's the court may make an order necessary to preserve and protect the safety and welfare of the child during the pendency of the appeal. It's that phrase that counsel is using to argue that that references some kind of time period before which the trial court cannot act. But the purpose of the statute reflects that that's really describing the relief. It's all going to be the relief that will go into effect to protect the children while the appeal is pending. There's other language in the statute that is consistent with that. Again, to Justice Rivas-Molloy's point, it says that the court, quote, retains jurisdiction, indicating that it's expanding the court's jurisdiction to act, not limiting it, that it can be granted until a date certain after the notice of appeal is filed, again, expanding. And we give the example in our brief where in practical application of the statute, it can extend the trial court subject matter jurisdiction and plenary power past when it would normally expire. And so that's inconsistent with reading it as if it's some sort of a procedural trap, that if the party makes a motion as it's entitled to do, even as far as before trial, is what the statute says, that if the court then grants that motion, and it just happens to be, in this case, days before the notice of appeal is filed, that that's somehow going to vacate the relief that it would otherwise satisfy the purpose of the statute.
Well, I think the argument was not that you can't file your motion before that time period. It's just the ruling has to come within the time period as described by the appellant.
Right. No, and I understand the argument. I would say that if you're allowing the parties to file the motion before, that's consistent with our view of how the language is designed to accomplish the purpose, which is to give the court maximum latitude to grant relief that would apply during the pendency of the appeal that all the parties in this case and other cases would be anticipating, even though that notice itself has not been filed.
Can we ask you to jump into physical custody next?
Absolutely.
Yeah, so I'll even let you kind of know where my thought process is on that is,
Okay.
I mean, I think there may be a judicial admission as to the legal custody, but what facts are there that show a modification, substantial and important material modification as to changing circumstances as to physical custody?
Perfectly valid question, and I would say that we're not relying on the judicial admission alone. I think that does kind of close the door on the legal custody issues, but I would say that the evidence that was offered at trial and the arguments that were made at trial, separate and apart from the judicial admissions and the pleadings, we were all in agreement, in essence, about this material and substantial change. And we cite to some of these concessions on page 50 and 51 of our brief. But Lilly testified herself under oath that the needs of the children have changed over time, including a host of medical, psychological, educational decisions. She also testified that and argued that the co-parenting had become impossible. This tiebreaker provision was a failure. And we know based on the record that some of those disagreements were so severe, like the school choice issue for APL, and I think revisiting in wake of some behavioral issues,
And the ADHD medication issue.
Right.
But all the stuff you just talked about, how does that go to physical custody, taking these kids from the home and putting them into a new home?
So I would say the Epps case is probably our best case on this issue. This is from this court where they went through.
I'm sorry, which case did you say?
The Epps case.
Oh, Epps, yes.
Where some of the issues between the parents were very similar. It's not going to be perfectly analogous because these things are so fact specific, but things like arguing about medication, failing to give notice about doctor's appointments, kind of playing games with the decision making in a way that were making it difficult for these parties to make any kind of agreements about how to care for the kids. That is the case where the issue under review was the determination of who has the primary custody of the kids, who determines the primary residence for the kids. But I would say in general, all of those things, I can understand, given the breadth of some of these concessions and the judicial admission, Lilly has no choice but to draw this line of demarcation as the physical custody issue. The issue with that argument is that there's no authority to support the court taking that kind of approach. And instead, all the case law repeats over time and time again that there's no rigid and definite guidelines for any of these rights.
But there is the best interest of the child, and what is there that makes it a best interest to take the children from Lilly and give them to Doug for primary residence?
I would say most of the same facts that relate to the material and substantial change, kind of the interference with the relationship, using the disagreements over decision making to kind of influence the relationship between Doug and the children. That's one that the courts would look to for best interest.
It seems to me that these are separate bundled rights, right? A lot of what you're talking about was resolved by the legal custody determination the trial court made. And so given the father the exclusive rights to make all these decisions would eliminate some of these issues. So I'm still struggling to see what the best interest, can you point us to the factors, the specific factors that relate specifically to physical custody that would have supported the trial court's significant change here?
I would say one of the most kind of painful to reiterate pieces of evidence on that fact is APL's testimony. We talk about that in the brief about how her mother makes her feel. That is an independent ground for changing the custody arrangement in addition to some of these other rights. I don't want to belabor that point. I don't think it's necessary to do that. The court also made specific findings that we cite evidence in support of, though, on things like Lilly making it difficult to make good decisions for the children, that Doug is the best parent who's in a position to do that well for the children, to look out for the children's best interest. And if that's the case, then having physical custody is logically related. There's a case that we cite on that point, and I understand Lily's point that it's, in that case, it was a mom who the court was referencing that she had physical custody, so it should make sense that she's getting these like final call decision-making rights. But the point of the court still applies in this case, which is if someone's in the final, the final decision maker on things like medicine, education, where the children go to school and what doctors they see, that it makes logical sense that you would then relate that to who is primarily in custody.
It would make a logical sense, but the statute is not drafted that way, and the authority that is given to the trial court on these issues, and they can sever these things out. So the court could have awarded primary residence to one parent and exclusive rights to the other. There's nothing that would dictate under the code that those rights be bundled together. And so the difficult task that we're having to make is to discern the reasons why, there is this finding as to legal custody, and then separate apart, there's this question as to physical custody, and then in addition to that, finding that that decision on physical custody was in the best interest of the children. And I realize the evidence, we read it, it's a 10-day trial, so there's a lot. But at least it seemed to be close enough that at least both parents were trying to do the best that they could for their children.
Certainly, and I agree that in some cases it might make sense to break out physical custody and require separate findings for that. It's just not required. The cases that talk about the different findings that go into material and substantial change and best interest, that fluid, they're sort of like non-exclusive. And there's not any authority that I've seen yet that sort of pigeonholes physical custody as being unavailable if all these other factors still relate to that. I think the question is the relatedness, but the standard, if you keep in mind, I think the lens to look at this through is the abuse of discretion standard. The question is, did the court have sufficient evidence to exercise discretion? And even if we might, in her seat, make a different decision about physical custody, she's the one that is there, listening to the witness testimony, judging the demeanor of these witnesses, trying to understand the very implicit issues like intent and motive and like what could be potentially harmful for these children and what's going to give them the best environment. And so I think the abuse of discretion is designed to be kind of a blanket over that, so that as long as there's sufficient evidence to exercise discretion, that all ties on sort of the close calls go to the trial judge who is in that seat.
Were the trial court's findings sufficient? Because that's one of the arguments on appeal. Was the trial court required to do more to tie the findings to the evidence or her reasoning to the conclusions that she reached?
So the authorities that the court has been provided all just require that the court make findings on material and controlling issues. This is not a case where we're left guessing why the trial court made the modifications that she did, because those were the only two kind of main issues for her to find. If this had been a jury trial, for example, those would be the two questions that you get to ask the jury. There's not a lot of other information that you get that would be relevant to your challenge to a jury finding on these issues. Because the purpose of the findings in the first place is to allow Lily an opportunity to meaningfully challenge those findings, the evidentiary sufficiency for those findings on appeal, and she's done that. We've got abundant briefing on whether or not that's borne out by this evidence. And I will say there is no case I've seen either cited or that I could find by myself where any court has been reversed because they did not make additional findings in addition to these two kind of controlling findings on material and substantial change and best interest of the child. I want to point out too, there's some reference to a constitutional problem. If we were taking the position that there were no findings required at all to support the modification, then yes, I agree that that would be a constitutional problem. But in the absence of any requirement for those findings, the Constitution is satisfied. The case that was cited that relates to motions for new trial and those being vacated, the rule itself says you have to find good cause to set aside a jury verdict, and you have to specify specific reasons for the good cause that you have found. That's not analogous to our case. There is no authority that would make the trial judges specify anything more than those two controlling issues. But set aside all of that, because the trial court did specify, we've got 7 findings at least that we're all talking about and comparing the evidence to that relate to the overall findings themselves.
Which of those findings go to physical the court's determination on physical custody.
So there's not one that references physical custody, that's a fair point. But again, the case law says that when you're making a determination about any of these rights, that's that fluid list of all the things that matter. And I don't think it's a stretch to say that, for example, if there's a difficulty with parenting, that Lily's got disruptive and combative conduct, that's for example in finding 12, but that's not somehow related to who should have primary custody of these kids. And there's an argument about whether we are asking the court to search the record to link up the findings. I mean, there are findings that relate to decision making that would go with the evidence about difficulty in decision making. There is not one that relates specifically to physical custody, but I would argue that those are still material to that issue.
That almost seems like once there's a determination made on legal custody, then it's a done deal. That physical custody is just an afterthought. And shouldn't there be some evidence there that makes it, hey, these kids are not thriving? There's some reason why they need to be taken from mom and given to dad.
I actually think there are cases, and we've cited some of them in both sides, where the determination on some legal custody issue is not going to be sufficient to change the physical custody. The Karanja case is a perfect example of that, where if the issue is over international travel, for example, whether the agreed order or the modification order should be changed to allow a child to be with a parent traveling internationally. That's not something that I think would be necessary to modify the physical custody for. But when you're talking about combative, with someone who is a finding that a parent is elevating their negative feelings about the other parent to the point that it's impacting negatively that parent's relationship with their kids, making it difficult to have informed decisions about things that are in their best interest, medical, psychological, school, what have you, those are things that I think are sufficiently related. That's the test, right? Like, if there has been a change, is it sufficiently related to the right you're trying to modify that justifies it? And I think when you're talking about that level of findings and that level of conduct, that is sufficient to modify the physical custody arrangements, even without a statement in the findings. But our primary argument is that the findings themselves are sufficient, that we've got the evidence in the record that is enough for the court to have exercised her discretion to make that change. I want to one last point on the best interest issue. There's reference to we all agree on the factors that go into that determination. I'm comfortable with the evidence that we've cited in our brief on that issue. There is one thing that keeps coming up, which is this recommendation by the amicus attorney, and I agree that was the recommendation. I wanted to point the court to the second volume of the reporter's record, 142 to 144. This is some testimony from Doug where he explains that amicus attorney met with him exactly one time. It was at the very outset of the case. It was right after she had been appointed, which is all that took place, I think, about a year and a half before trial. She never went to his home. So I do think the court understood that she could take into account that fact when she's considering how much weight to give the amicus attorney's recommendation on best interest, given the volume of the other information that she had before her to exercise her discretion.
Counsel, on the issue of the judicial admission, since we are talking about the difference between legal and physical custody, is it your position that Ms. Lerner has judicially admitted physical custody or simply legal custody, or do you think there's no difference between the two?
Simply legal custody. The position we took in our response brief tried to make it clear, but in case it's not, I agree that the judicial admission would only be as to legal custody. The reason for that is because that only applies, the admission is only for the rights you're trying to change, and she was not trying to change physical custody. I will say, though, the concessions at trial I consider to be in a different camp, because at that point she's fully aware that he is trying to change physical custody, and she makes the concessions about the needs of the children changing and these just impossible, unbreakable ties that they're having on decision making, with no caveat about which rights those would relate to, either by herself or her counsel. So I do think that those are fair consideration for other rights as well.
Okay. Well, counsel, as we've been discussing it, it does seem that the law separates these bundles of rights into two separate categories. And so, is there any point at which, if you're arguing at trial with these overlapping things, do you feel like that Ms. Lerner needed to specifically articulate this is for legal and this is for physical if she wanted to talk about it in different ways? Because it seems like you're also arguing that it's all the same thing.
I think if you were going to take the position that she's conceded certain things but not as to physical custody, you would have to draw that line of demarcation at the trial to make the court aware that you're not saying that the change is enough to account for physical custody that's also being requested by the other party. The rights, I agree, the rights are treated differently. The trial court can carve up these different kinds of rights anyway within their discretion, but whether the evidence itself relates to all these rights and is sufficiently tied to it to justify modification, I think is a different question. And that's where the Epps case, and then we've got the Arendonda, anytime you're reciting these factors, the factors that go towards whether you can modify certain rights, there is no line of demarcation between legal and physical in that sense. So the evidence that you're analyzing is all fair game for physical custody along with legal custody.
Yeah, your point being that some evidence could be the same and can underscore each one of them. You don't have to have separate buckets of evidence supporting the bundle of rights.
Exactly.
I understand what you're saying.
Thank you.
But you believe that it's the party's duty to say which and not the judge's duty to decide which?
I think if you are saying that there's a material and substantial change across the board, it's hard to then back out of that on appeal and say, well, that change only applies to one type of rights and not the other. But the court couldn't properly use that to find that it is, in the court's view and in the discretion of the trial court, sufficiently related to the change in physical custody.
And I don't think we disagree with you. I think the difficulty is just streamlining the evidence that was presented and tying it into each one of the modifications, which I believe we're required to do. So it's not that the evidence was there, the question is, does it directly tie to the specific modifications that the trial court made? And while we're following on the legal custody, we're needing your help to tell us how it tracked, and I think you've been doing it, how it tracks into the legal or the physical custody decision or modification in this case.
Exactly, and I do think, part of the problem in responding to that without just saying all of it is that our view is that all of it does go into that determination, that you can't decide an issue as important as physical custody without considering all of this evidence and how this relationship between the parents is negatively impacting the children, and that includes where they live.
And you had, of course, APL saying that she wanted to go to dad, and then you had TL saying happy with mom. So
right.
We'll split there too.
It's tough. It's just, that stuff is tough to read, much less summarize for the court, so I appreciate the difficulty of some of these issues. One thing I do want to say on the remedy for the discrete finding issue, because I see I'm running out of time, the remedy for that would be to abate this case and go back down for more findings. And I don't know that that's necessarily going to accomplish anybody's objectives if there were a determination by the court. So I just wanted to point that out. The other issue is that whether we're talking about sufficiency of the evidence to support exercise of discretion on fees or some of these other issues, the remedy is actually a remand. And I can
on fees.
On fees. Yeah, so, and I've got case citations for the court on that issue. The Grant v. Grant case, 2015 Westlaw 543-8949. And then the Watson v. Watson case, 286 Southwest 3rd, 519.
That would be only as to the sufficiency, right, of the reasonableness and equity, the reasonableness of the fees or the sufficiency to support the fees under the statute. Not, obviously, we're not talking about the jurisdiction or the ability.
Correct.
You're talking about if there's a sufficiency issue, your position is that that would be a remand.
Correct.
On that point. If separating that out, because I asked the appellants this question, if we were to agree with you that there's sufficient evidence on the legal custody determination, but disagree as to physical, what would be the remedy in that case?
I don't know the answer to that off the top of my head. That'd be something that I would like to look at if that's the line of demarcation that the court is faced with, and provide an additional letter brief or something that would provide that answer. Typically in this two-step process, the same logic that applies for fees actually I think applies for the rest, which is that if the issue is there was not enough evidence for the trial court to exercise its discretion, that's a remand issue. That's not something where you could completely change the judgment that was signed.
You would disagree that it would be, we would vacate and render?
I'm not sure that there's authority for that. Again, that's something that I would want to look at more carefully before I say definitively.
And
I think it's an important
we'll give
issue.
the parties an opportunity to address that. We can always issue a letter asking for that specific information.
Understood. Thank you.
Thank you. We're ready for appellant's rebuttal?
May I take 5 minutes, Your Honor?
Yes.
Let me begin with Karandra. The conclusion there was that the court vacated the modification order, so vacate is appropriate. And let me also, my friend on the other side, Ms. BRIECK, made a comment about distinguishing jury answers and findings. Well, in this case, with the findings have the effect of the jury's answers on special issues. That's the way they're treated. And what cabins this court's review is this. There is no finding, and if you look at the record, no legally sufficient evidence of a material and substantial change that relates to the physical residence of the children. They are two categories, two buckets. There are hundreds of cases on the books where one is modified, but one isn't. And the reason they have that conclusive effect is that we filed a request for amended findings and the trial court declined it. Let me talk a little bit about this idea that you can
Can I ask you a real quick question on that?
Yes, Your Honor.
If that is if there were additional findings that need to be made, would the relief be to abate and send it back for additional findings?
No, Your Honor. They could have done that. The time is up. Karanja tells us, then there are dozens of cases that tells us when a modification is on appeal, if there is no evidence of material and substantial change, the remedy is to vacate. And the reason it's so important, Mr. Lerner's back in court on another modification. The relate back date would be the agreed decree of divorce. It wouldn't be this erroneous, egregious modification of primary custody. And it's very critical. I wanted to talk just a minute about the importance of differentiating between a best interest finding under Chapter 153. Best interest, anything goes. Modification, the legislature recognizing the policy of stability and finality set a very high threshold. And there's a reason for that. You don't uproot children. You don't take them from their homes. If the court finds there's sufficient evidence in this record to give Mr. Lerner the right to make medical decisions, the court could do that. Or the court could put them with the person who should have primary custody. One last point, and then I'm going to give 2 minutes to my colleague, Ms. Jamison. Estate of Brown. It's a case out of the Texas Supreme Court in 2022, 704 Southwest 2nd 3rd 428. In that case, it was a guardian ad litem for the ward. And in our case, it's an amicus that's been specifically charged with advocating for the children and advising the court. She made statements, I think they were characterized as a recommendation. They were not objected to. And so that is evidence in this record that does go to primary custody. The children are fine, they're happy, they're stable. And I want to thank the court for your time. I see that I'm at 1.49. I'll see the rest of the time to Ms. Jamison. Yes,
Counsel,
Your Honor.
one quick question. Can you give us an example of evidence that would be sufficient to change physical custody?
I have to look in the findings, and there's nothing here. If you look at the cases that actually change physical custody, when they say hostility, parents sometimes physically attack each other. When there's abandonment, there's too many lovers, too many moves. Those are cited in our brief. Drugs, but strong use of drugs, not casual, strong use of drugs. Thank you for that question. When you see a change in primary residence because of the need for stability and finality, because someone flipped someone off, that's simply not enough. And if it were, I think every child in this state is in danger. Thank you, Your Honor.
Thank you, Counsel.
Thank you.
Your Honor, I just wanted to briefly make 3 points regarding the attorney fee order. Number one, sufficiency of the evidence. I just wanted to draw the court's attention to 2 cases that we cited. The Jenkins case out of the Waco Court of Appeals, and then also the Carter case out of the San Antonio Court of Appeals. Both of those were original proceedings. The Court of Appeals reviewed appellate attorney fees under 109.001, found that the evidence was not sufficient. Those 2 cases are important because the facts are very similar. The fee recipient did not have rent or mortgage payment. The fee recipient also did not pay for household expenses. The courts of appeals in those cases set aside the order and vacated. Second point I want to make is...
And your point is that you would disagree that it would be a remand?
That's correct, Your Honor. We brought this as an original proceeding, which the statute allows, and so looking at Jenkins and Carter, the proper remedy is for this court to conduct its own analysis, determine whether or not there was an abuse of discretion because there's insufficient evidence, and to vacate the order. That's what Jenkins says, and that's what the
What
Carter
if we
case
consider it as
says.
part of the appeal? As an appellate issue? Instead of
It's in the direct appeal also, and I think even in the direct appeal, the proper remedy is not a remand. This court should review the order to see whether or not there was an abuse of discretion by the trial court overlaid with the sufficiency standards, and if there's insufficient evidence to support it, this court should vacate the order. And then the last point I want to make regarding the trial attorney fees. Again, plain reading of the statute, it's fees pending an appeal, and that makes sense because typically by the time you get to an order that's issued under 109.001, the trial court has already made a determination on fees. And in fact, in this case, both sides asked for trial fees, and in the modification order, that attorney fee request was denied. So the statute contemplates only appellate attorney fees. And if you look at the cases that have addressed appellate attorney fees, and specifically the category of appellate attorney fees, the courts of appeals talk about how they have to be conditioned. The fees that are awarded have to be conditioned on a successful appeal. So the statute contemplates only appellate attorney fees, and the cases that have interpreted the statute talk about appellate attorney fees. And so the proper remedy here, again, we've brought the original proceeding, but even the direct appeal would be to vacate the order and not send it back for the court to do a do-over. There's no other question from the panel?
No, thank you very much. Thank you to both sides for your excellent argument and your excellent briefing. This case is now submitted, and we are now adjourned.
All rise.